If you are a private carrier not transporting hazardous material, these insurance questions will not apply. Motor carriers of property operating commercial motor vehicles in interstate, foreign, and interstate commerce, and for-hire carriers of passengers operating in interstate or foreign commerce must have at least the minimum amount of insurance required by law. The carrier is required to have a financial responsibility form, like the MCS 90 or MCS 90B, on file issued by the insurance company. The carrier must retain an accident register. All accidents meeting the following requirements should be documented: a fatality, bodily injury to a person who immediately receives medical treatment away from the scene of the accident, disabling damage to one or more motor vehicles, requiring the vehicle to be removed from the scene by a tow truck or other vehicle. Motor carriers are required to maintain an accident register. Copies of accident reports should also be on file when required. Every commercial motor vehicle operated by a motor carrier in interstate commerce must be marked on both sides with the following: motor carrier's name or trade name, motor carrier's identification number preceded by U.S. DOT. These markings must be visible from 50 feet and displayed in a contrasting color. Carriers are required to either obtain a printed copy of the Federal Motor Carrier Safety Regulation Manual or have Internet access to the Federal Motor Carrier Safety Administration website. Drivers must meet these qualifications to be qualified to drive a commercial motor vehicle. Be in good health and physically able to perform all duties of a driver. Be at least 21 years of age. Speak and read English well enough to converse with the general public, understand highway traffic and signals, respond to official questions, and be able to make legible entries on reports and records. Be able to drive the vehicle safely. Know how to safely load and properly block, brace, and secure the cargo. Have only one valid commercial motor vehicle operator's license. Provide an employing motor carrier with a list of all motor vehicle violations or a signed statement that driver has not been convicted of any motor vehicle violations during the past 12 months. A disqualified driver must not be allowed to drive a commercial motor vehicle for any reason. Pass a driver's road test or equivalent. Complete an application for employment. Possess a valid medical certificate. All drivers that operate for a company, including an owner that also performs the duties of a driver, must have a qualification file. This file must contain the following: driver's application for employment. A person will not be allowed to drive a commercial motor vehicle unless he or she has completed and signed an application for employment. Inquiry to previous employers, 3 years. An investigation of the driver's employment record during the preceding 3 years. This investigation must be made within 30 days of the date his or her employment begins. Inquiry to state agencies, 3 years. The driver's driving record from the preceding 3 years. This investigation must be made within 30 days of the date his or her employment begins. Inquiry to state agencies, annual. Request driving record annually for each driver. Annual driver's certification of violations. At least once every 12 months, a motor carrier must require each driver that it employs to prepare and furnish it with a list of all violations of motor vehicle traffic laws and ordinances during the previous 12 months. Note: drivers who have provided information required by Section 383.31 need not repeat that information in this annual list of violations. Annual review of driving record. At least once every 12 months, a motor carrier must review each driver's record. A note stating the results of this review shall be included in the driver's qualification file. Driver's road test certificate or equivalent. A person must not be allowed to drive a commercial motor vehicle until he or she has successfully completed a road test and has been issued a certificate or copy of the license or certificate which the motor carrier accepted as equivalent to the driver's road test, pursuant to Section 391.33. Medical examinations. The driver must pass a medical examination conducted by a licensed healthcare professional. This examination covers 13 areas which directly relate to the driving function. In the case of failed vision or hearing, insulin-using diabetes, and epilepsy, the medical examiner may not grant a medical certificate. This medical certificate must be carried at all times and must be renewed every 2 years. Keep in mind that there are different rules for passenger-carrying vehicles than for property-carrying vehicles. Carriers are required to keep records of duty status for 6 months. A driver must carry a logbook or have detailed time records such as time cards, maintained at the company office. This also applies for owner-operators. In some cases, your operation may be eligible for an exemption from keeping records of duty status. For example, the 100 air-mile radius exemption, short-haul exemption, and farm exemptions. These rules are subject to the exceptions and exemptions in Regulation 395.1. No motor carrier shall permit or require, nor shall any driver operate, a property-carrying commercial motor vehicle more than 11 cumulative hours following 10 consecutive hours off-duty, or for any period after the end of the 14th hour after coming on duty following 10 consecutive hours off-duty, except when a property-carrying driver complies with the provisions of 395.10 or 395.1E2. No motor carrier shall permit or require, nor shall any driver operate, a property-carrying commercial motor vehicle, regardless of the number of motor carriers using the driver's services, for any period after having been on duty 60 hours in any period of 7 consecutive days, if the employing motor carrier does not operate commercial motor vehicles every day of the week, or having been on duty 70 hours in any period of 8 consecutive days if the employing motor carrier operates commercial motor vehicles every day of the week. Any period of 7 consecutive days may end with the beginning of any off-duty period of 34 or more consecutive hours. Or, any period of 8 consecutive days may end with the beginning of any off-duty period of 34 or more consecutive hours. Drivers of property-carrying CMVs, which do not require a commercial driver's license for operation and who operate within a 150 air-mile radius of their normal work reporting location, may drive a maximum of 11 hours after coming on duty following 10 or more consecutive hours off-duty, are not required to keep records of duty status, rods, or logs, may not drive after the 14th hour after coming on duty 5 days a week or after the 16th hour after coming on duty 2 days a week. Employer must maintain and retain accurate time records for a period of 6 months showing the time the duty period began, ended, and total hours on duty each day in place of rods or logs. Drivers who use the above-described short-haul provision are not eligible to use 100 air-mile provision 395.1E or the current 16-hour exception in 395.10. Passenger-carrying carriers and drivers are subject to different hours of service rules. These operations must comply with the hours of service limitations specified in 49 CFR 395.5. No motor carrier shall permit or require any driver they use to drive a passenger-carrying CMV, nor shall any such driver drive a passenger-carrying CMV more than 10 hours following 8 consecutive hours off-duty or for any period after having been on duty 15 hours following 8 consecutive hours off-duty. No motor carrier shall permit or require a driver of a passenger-carrying CMV to drive, nor shall any driver drive a passenger-carrying CMV, regardless of the number of motor carriers using the driver's services, for any period after having been on duty 60 hours in any 7 consecutive days If the employing motor carrier does not operate commercial motor vehicles every day of the week, or, having been on duty 70 hours in any period of 8 consecutive days, if the employing motor carrier operates commercial motor vehicles every day of the week. You will need to refer to the Federal Motor Carrier Safety Regulations for a more detailed explanation of these rules and possible exemptions. These regulations deal with general operation of commercial motor vehicles. The motor carrier should ensure that drivers operate CMVs in accordance with the laws, ordinances, and regulations of the jurisdiction in which they are operating. The motor carrier should ensure that drivers always properly distribute and secure any cargo. The motor carrier should ensure that no driver operates a CMV while under the influence of or in possession of intoxicating beverages, narcotic drugs, amphetamines, or any other substances capable of impairing the driver's ability to safely operate the motor vehicle. Motor carriers must maintain the following information for every vehicle they have controlled for 30 days or more. Identifying information, including company number, make, serial number, year, and tire size. A schedule of inspections to be performed, including type and due date. Inspection, repair, and maintenance records. Records of tests conducted on buses with push-out windows, emergency doors, and marking lights. These records must be retained for 1 year at the location where the vehicle is garaged and maintained for 6 months after the vehicle leaves the carrier's control via sale, trade-in, or scrap. Every commercial vehicle, including each segment of a combination vehicle, requires periodic inspection that must be performed at least once every 12 months. Inspections must include all items listed in the Minimum Periodic Inspection Standards, Appendix G to Subchapter B. Carriers may perform required annual inspections themselves. The original or a copy of the periodic inspection report must be retained by the motor carrier for 14 months from the report date. Motor carriers must ensure and document that persons performing annual inspections are qualified. Inspectors must understand the inspection standards of Part 393 and Appendix G. At the completion of each day's work, every driver must prepare a driver vehicle inspection report, otherwise known as a DVIR, or post-trip inspection. This report will be prepared for each vehicle driven. This report must cover at least the following parts and accessories: service brakes, including trailer brake connections, parking handbrake, steering mechanism, lighting devices and reflectors, tires, horn, windshield wipers, rear view mirrors, coupling devices, wheels and rims, emergency equipment. Carriers must keep the original post-trip inspection report and the certification of repairs for at least 3 months from the date of preparation. Before driving the vehicle again, the driver should review the previous day's DVIR and be satisfied that the vehicle is in safe operating condition. This process ensures that defects and deficiencies are corrected. Federal law requires that you must have a commercial driver license to operate a single vehicle with a gross vehicle weight rating, GVWR, of more than 26,001 pounds, a trailer with a GVWR of more than 10,000 pounds if the gross combination weight rating is more than 26,001 pounds, a vehicle designed to transport more than 15 persons, including the driver, any size vehicle which requires hazardous materials placards. Carriers must ensure that their CDL drivers have a current operating license that is properly classed and endorsed. Only CDL drivers are subject to the controlled substance and alcohol testing rules. These rules apply to both interstate and intrastate carriers. Carriers will perform the following DOT tests when required. Pre-employment. No employer shall allow a driver to perform a safety-sensitive function until they have received the negative controlled substance test result. Post-accident. As soon as practicable following an accident involving a CMV operating on a public road in commerce, each employer shall test for alcohol and controlled substances each surviving driver who was performing safety-sensitive functions with respect to the vehicle if the accident involved the loss of human life, or who receives a citation under state or local law for a moving traffic violation arising from the accident, if the accident involved bodily injury to any person who, as a result of the injury, immediately receives medical treatment away from the scene of the accident, or one or more motor vehicles incurring disabling damage as a result of the accident, requiring the motor vehicle to be transported away from the scene by a tow truck or other motor vehicle. If a test required by this section is not administered within 2 hours following the accident, the employer shall prepare and maintain on file a record stating the reasons the test was not promptly administered. If a test required by this section is not administered within 8 hours following the accident, the employer shall cease attempts to administer an alcohol test and shall prepare and maintain the same record. If a test required by this section is not administered within 32 hours following the accident, the employer shall cease attempts to administer a controlled substances test and prepare and maintain on file a record stating the reasons the test was not promptly administered. Random. Companies are to randomly test drivers at a minimum annual percentage rate of 10% of the number of drivers for alcohol testing and 50% for controlled substances testing. The random alcohol test must be performed immediately prior, during, or immediately after a driver is about to or has performed a safety-sensitive function as defined in Section 382.107. All drivers must have an equal chance of being selected each time a selection is made. The carrier must use a scientifically valid method to make this selection. This can include a random number generator or a computer program that will randomly pick drivers. An owner-operator must belong to a consortium to satisfy the regulation for random testing purposes. Reasonable suspicion. An employer shall require a driver to submit to an alcohol and/or controlled substances test when the employer has reasonable suspicion to believe that the driver has violated the prohibitions concerning alcohol and/or controlled substances. The employer's determination that reasonable suspicion exists must be based on specific, contemporaneous, articulable observations concerning the appearance, behavior, speech, or body odors of the driver. The required observations shall be made by a supervisor or company official who is trained in accordance with 382.603. Return to duty. Each employer shall ensure that before a driver returns to the performance of a safety-sensitive function, the driver shall undergo a return to duty test. Alcohol tests must indicate an alcohol concentration of less than 0.02. The return to duty controlled substances test must indicate a verified negative result for controlled substances use. If a currently employed driver tests positive for a controlled substance or alcohol, you should immediately have that driver cease driving.
Joe, this is Matt from the safety department. Listen, I have your drug test results back from your random drug test. They came back positive. What I'd like you to do is stay at the location where you are, there at that truck stop. In 3 to 4 hours, I'll have a relief driver to you. Let him take the load forward, and I'll have somebody bring you back to the office. Do you understand me?
That driver cannot drive again until he has seen a substance abuse professional and you have received a negative return to duty test. Your own company policy will dictate whether or not you retain this driver's services. Follow-up. The substance abuse professional will establish a follow-up testing plan. The employer must ensure that the follow-up testing plan is carried out. A minimum of 6 tests must be conducted in the first 12 months, and the driver may be subject to this test for a maximum of 60